Critics of Canada's controversial anti-terrorism legislation, that's Bill C-51, call its powers unprecedented and its capacity for intrusive surveillance and information sharing a threat to the privacy rights of all Canadians. Yet, even now, law enforcement agencies are lobbying the federal government for extended powers, warning that Canada's security lags in this digital era. Joining us now on how to find the right balance between privacy and effective policing, we're joined by Scott Todd. He's Deputy Chief of Police from the North Bay Police Service. Sukanya Pillay, Executive Director and General Counsel, Canadian Civil Liberties Association. Christopher Parsons, Managing Director, the Telecom Transparency Project at the University of Toronto's Citizen Lab. And Robert Cribb, Investigative Reporter at the Toronto Star. And we're happy to welcome all of you to our table here at TVO tonight. Get comfortable, everybody, because I'm going to read a couple of things first, just to set up our discussion. Sheldon, if you would, let's bring these up. This is from Our Security, Our Rights, National Security Green Paper. We treasure our privacy, and rightly so, but we also expect law enforcement and national security investigators to be as effective in keeping us safe and secure in the digital world as they are in the physical world. But our laws on how information can be properly collected and then used in court as evidence were mostly written before the rapid pace of new technology became a consideration. And let's follow that up with one more here. This is from the aforementioned Mr. Cribb, writing in the Toronto Star last month. I can safely say that there's criminal activity going on every day that's facilitated by technology that we aren't acting on. That's a quote from RCMP Commissioner Bob Paulson, telling the Star and CBC News in an exclusive interview. We're losing our ability, if we haven't lost it entirely, to bring the traditional investigative response to technologically facilitated crime because of the misunderstanding, in my view, of the privacy threat. So those essentially are kind of both sides, generally speaking, of the argument. So let's get into this. Deputy Chief, let's start with you. What are the police looking for in terms of changes to legislation that you think you need to do your jobs better?
Primarily, we're looking for four things. This past August, the CACP, the Canadian Associations of Chiefs of Police, passed a resolution that was looking at consideration be given in resolving the matter in regards to encryption and access to mobile devices or other devices that are password locked. And that what we asked for was some type of reasonable law that would allow law enforcement, more specifically for me, police officers, to have access to encrypted devices or to devices that are password protected so that we could continue on in the investigation and collect further evidence. That was the first one. The second one is warrantless powers to have basic subscriber information.
Translation, please.
Basic subscriber information, or BSI, is the name of an individual subscriber, the IP address, perhaps an email address, and location of where that IP address lands in regards to drop. The other thing we look for is data retention standards and data retention regulation or standards, so that telecom companies and ISP companies are required to store data for a specific period of time. And it could happen through regulation or it could happen through some other type of order. And the last one we're looking at is in regards to interception capabilities. And that's the ability for law enforcement with warrant, a judicial warrant, to intercept in a tangible fashion information that has meaning to us. Because right now we don't.
Which now you don't have. Those are the 4 points. Robert, as you look at those and through your coverage, anything controversial in any of that?
Everything about that is controversial. Yeah, this is an incredibly polarized debate. So we went in detail on those 4 issues. Canadians feel very strongly on one side or the other. I think we are really in our infancy in our understanding in this country of this. I don't think there's a lot of public literacy around these issues. I don't think we've aired it out, in part because we haven't had the information on the table. But there is very strong division between the police position and that of civil libertarians. And I think it's unfortunate, actually. I think that, in fact, it's a much more textured, subtle debate. It's gray, it's filled with gray, and yet that's not been translated, I think, to date. It's been very much a black hat, white hat debate.
Who's wearing the black hat, who's wearing the white hat?
It depends on your perspective. Certainly, I think that those who have a strong privacy bent and great concerns legitimately about privacy in this country feel that the police are trying for a power grab. They're trying to arrest powers that will allow them to surveil us on a mass level. And I think on the other side, the police, people like Bob Paulson, feel that they're being demonized by the privacy advocates who don't understand the very real, tangible needs of police to solve crimes involving sometimes, horrific cases where there's real victims.
Let me put one of Mr. Paulson's comments to Sukanya right here. You heard him say that Canadians misunderstand the privacy threat. What's your view on that?
I respectfully disagree. I think that Canadians do understand the privacy threat, and I think that Canadians are concerned. Let me say that Canadians definitely want to assist the police in their work, and I think we understand that they need to have information and they need to have access. Our concern, based on Canadians who speak to us and also the law, is that that access has to be grounded within a wider context. We have to look at what privacy actually does for us and when we're willing to allow infringements of that privacy or legitimate infringements. And I think that that's being lost. And I think that when the debate is presented as black or white, we run the risk of losing what's really going on in the middle and why we have privacy in the first place.
Is there a way to meet in the middle on this, Chris?
In some areas, there certainly are. Perhaps not all the way. So I think warrantless access to data is one area where there's been contention, and the Supreme Court of Canada has fallen out and said actually that's a no-go space. But legislation could be proposed, and I think that both law enforcement and civil liberties groups and academics such as myself could work towards developing. And this has been proposed. So setting the standard appropriately so there is some sort of oversight makes sense. In the past, police do and have gained access to subscriber data using warranting power. Not exclusively, but they have. And so we need to unpack that debate to understand what has changed, why were warrants used in at least 50% of the time in the past with some agencies, whereas it's fallen off a cliff now. And so that's an area we're having a debate with law enforcement, understanding the past, the present, and where to go forward is needed to have that robust discussion.
Let's understand that a little better. Can you give us for instance, of where you would be working on a case where you currently believe you don't have adequate powers to do your job properly?
It could be as simple as a complaint that is provided to a patrol officer about an information that someone's been attacked over the internet or through their mobile device. It could be some type of ransomware, or it could be a threat of some sort, a sextortion, and that the only information that we're able to get at that time is an IP address. That would lead us back to go to where we'd like to see the individual. So,
and in your view, that's not...
It's a starting point, and that's all it is
enough.
for us. It's not enough. And
not enough to help you do what?
To identify an individual who's committed a criminal act. And that is what the threshold is for evidence in the court, is we can't put a device or some type of other instrument, a technical instrument, on the stand. We have to put a human being on the stand, at least to face the prosecution of what the charges are.
What's your concern about giving the deputy chief, who seems like a very fine fella, additional powers in order to help him do his job better?
Well, I think that we don't start from the standpoint that the police are necessarily out to grab as much information as they can, but we do very much study history, and we know that when powers have been given to people, even a well-meaning and earnest police officer may go beyond what is legitimate. The other thing that we're concerned about, so that in other words, they may grab more information than's actually needed, and they may also have access to very personal identifying information on the habits, on the sites that are visited, et cetera, of innocent law-abiding Canadians. And that really concerns us, because once you start going down that path, you're really going down a path of altering what is otherwise a free and democratic society. Any time that a state feels that it has to know all the time everything that's going on, you no longer have a free and democratic society. We only need to think to the Cold War, or even to other countries in the world right now where there's that all the time surveillance. So we don't want to be treated like suspects.
Okay, Robert, what about, well, everybody's concerned about terrorism, right? What if the chief thinks he's got a tip on a potential terrorist activity that may happen somewhere in Northern Ontario, and he needs additional powers in order to root out the potential suspect? Who doesn't want to give him that additional power?
Yeah, so it's really interesting. We looked at 10 cases. We negotiated access to 10 cases. Many of them were, in fact, terrorist national security cases where the police alleged that they hit a roadblock, effectively a digital roadblock, where they were unable to pursue perpetrators of alleged crimes because of encryption or because they couldn't get access to vital digital information. It had been purged, perhaps in some cases, by ISPs. And so we spent I've been working on this for 2 years. I have come to believe that this is not a fiction that the police are making up. I have come to believe through sitting in countless meetings and looking at countless documents that this is real.
They have a case.
They have a case. I do believe that. I think there are cases that we've looked at very carefully. Some of them are terrifying cases, child abuse cases where there's evidence sitting on phones that they can't get access to. So I really do think that there has to be some thoughtful consideration to these concerns. There's no question about it. And at the same time, I'm straddling here because I'm a journalist and I have grave concerns about the kinds of abuses of power that we're actually sort of seeing. And it happened recently in Quebec. So the question is, so what do we do about that? And where is that middle ground? And I think that's what we haven't figured out yet. We're not even close to having figured that out because we haven't had the public debate. And what's really interesting is here we are in the process of public consultations. Like, we're moving very quickly towards some sort of legislative reform, and I just don't think we're ready.
Do you have any difficulty giving the police this additional power that they want in order to root out child abusers and potential terrorists and that kind of thing?
Yes.
You do?
Not because I don't think those people should be stopped, because they should. Some of the proposals are not privacy issues. They are, but that's the secondary consequence. The primary consequence is security. This is a security versus insecurity discussion. To use the example of encryption. So to provide police access to encrypted devices, there's several ways that you can go down that road. One of them would be compelling individuals to disclose their passwords or decryption keys or something like that. And Sukanya might be able to talk to the legal issues about self-incrimination, which actually the RCMP commissioner has also said is probably a no-go. So what's the other major way that you could go through that? Well, you could set up backdoors or key escrows or ways that technology companies would have to design their security systems to have a way for police to gain access into it. Sadly, cryptographers and security engineers are having a devil of a time right now trying to maintain security where they aren't building backdoors in. And we know when backdoors have been built into security, so this has been done by the Canadian government in the past, and it's happened in other instances, hackers get through it very quickly. And that's isolated sorts of situations. When we talk about enabling access to huge volumes of communication with thousands or tens of thousands or millions of persons' communications, it starts to unravel the past decade's worth of security. And while yes, it might mean that we can catch certain serious criminals, which would be a good thing for society, it would also render society more broadly vulnerable to equal attacks from other state actors, from criminals, from the very people we're trying to protect ourselves against. So that's a part of the debate that no one knows how to have it, because so far the smartest people that are building these tools have no idea how you could possibly build those backdoors in.
So help us, Deputy Chief, understand how we can give you more power to do what you feel you need to do, while at the same time not casting the net so wide so that we enable a lot of potential activities that we don't want you doing.
One is law enforcement and policing needs to do a better job at talking about what it is we do and what we don't do. And we haven't been good at talking about what we don't do. We don't, in policing, to my knowledge, and I've been at this 35 years in a number of roles in policing, we don't have a mass surveillance program. The concept of a mass surveillance program being run by police across Canada, to me, is ludicrous in the fact that we don't have budget, and we don't have people right now to keep up with the incidents and the reported incidents that come through our door right now that require some type of electronic crime response by our technicians. To do more is going to be challenging. To say that we're going to have these unlimited powers and that we're going to be creating a difficult problem for many individuals in society, simply we don't have capacity right now to even deal with what's coming through the door right now. So how we would be attacking society otherwise, I'm not sure. But what we're looking for is reasonableness. And I think the whole aspect is, in the absence of a law, and that's one of the decisions called Spencer talked about, in the absence of law, Spencer talked about police officers needing a warrant. And they were, at the time, collecting information that I call lifestyle information. It was information beyond what the basic subscriber information is. So I think a reasonable procedure, law, regulation, whatever it turns into be, that says that we can only collect warrantless on BSI, the name, of the subscriber, the IP address, perhaps an email address, and the physical address and name. That's basically all we need at that level to start an investigation or to further an investigation so that we can go to warrant powers. On the encryption side, it's frustrating, very frustrating with victims when we get to the end where we have a device that we need to go into and to access information or images that are in there, or information in a text message, and we can't do it through the interception of the message, but it's perhaps an extortion, teenage extortion being done. And the fact is that we have to get into the suspect's phone to prove that the suspect was at that time sending those messages. We have the victim's phone, but when we can't get into it, and we have written off investigations in those cases where we can't access the information in the suspect's phone.
And therefore, guilty people have gone free, in your view?
I wouldn't say they were guilty at that time, but certainly strong suspects in an investigation.
Okay. You mentioned, sorry, I want to go over here to Sukanya for a second, because you mentioned the Spencer decision in the midst of that answer. And just take a few seconds here, and because I guess the Spencer decision from a couple of years ago set the table for the privacy rights that we currently enjoy as far as the courts have interpreted them. Is that fair to say? Like, where are we today in terms of what the courts say we're entitled to and not?
Well, I think the Spencer decision was very important because it clarified for us once and for all that on the internet, users have a reasonable expectation of privacy, and they have a right to anonymity, and that's important when we're talking about digital information. The second thing was that when police want to access basic subscriber information, et cetera, they need to get a warrant or they need to get a production order. In other words, they need to have judicial authorization to access it. And so that was very important. And the discussion that we're having today does worry privacy advocates like myself or perhaps Chris, because this very important decision that sets limits might be overturned. And the very issues that both Mr. Todd and others have brought up we can argue them also the other way. So it's important to look at the context, and it's also important, as Chris pointed out, to look at how encryption actually helps us as a society. Like, we don't want to swap one set of crimes for another.
I would like to play a little piece of clip right now. Robert, this is part of your series we're going to play here. You spoke to the RCMP Commissioner, Paulson, and you asked him the following question. Roll it, please.
Are we more or less safe as Canadians today as a result of these technological advances, in your view?
That's a good question. I think we're more safe. I think we're more safe as a result of a number of other things other than technological shifts. I think the risk is that it's precarious. Our safety and security is precarious. I need to not make the case that the sky is falling, because that's not my case. I'm saying that the sky is wobbling, that there's a storm over there. Hey, look, there's a big storm. Can you tell which way it's coming? I think it's coming this way.
Obvious question out of that clip is, what are those swords doing in the background? No, never mind that. Never mind that. Let me ask you, as a reporter, do you feel more safe as a result of the digital tools that you have access to now?
Listen, it's like every question on this issue, it's textured. So, listen, as a journalist in the aftermath of recent stories about surveillance of investigative journalists in Quebec who were doing tremendous work that brought vital issues of public interest to light and affected public policy, I think it's terrifying. I think it's terrifying, this notion that the work of journalists could be, and their location and the work that they do and the sources that they speak with could be surveilled in that way.
Who was surveilling them?
Both local police and provincial police were surveilling them.
What were they trying to find out?
Their sources. Who they're meeting with, when, how.
What did they find out?
Well, we don't know exactly what they found.
They haven't fessed up.
No.
Can you see why this would make, giving you extra powers would make some people skittish?
Absolutely. And one of the only panelists here that probably has an oath of duty that to uphold our Charter rights and freedoms for all citizens in Ontario. And we take that very seriously. I take it very seriously. So whenever we do have discussions such as the discussions we're having today, we look at our foundations and our principles of policing. And one of mine is to uphold the Charter rights and freedoms and to enshrine those rights for the citizens of Ontario. So we do take this seriously. And we've been looking to have this conversation for the last 3 or 4 years since I've been around C13 and C30, and it's nice to have the discussion now in open forums and with esteemed guests in our siloed communities that we are now having discussions. So I understand it quite well.
What do you think the cops in Quebec were thinking?
I can't comment on the Quebec case.
Oh,
I have
sure you
no
can. Go
particular
ahead. Come
information
on.
what goes on there, but as I said, the Charter of Rights and Freedoms to us are one of our foundation principles, and I do see the freedom of the press as being related to that, the Charter of Rights and
Is that
Freedoms.
happening here, Scott? Is that happening in Ontario?
Not to my knowledge, it hasn't. No.
I'm not under surveillance.
No, you're not.
Thank you. That brings some relief.
Do you think there's well, you're the lawyer. Let me ask you. Do you think there's a possibility that because Quebec has not signed the Constitution, that somehow the police felt that they didn't have to follow the Charter?
Well, that would just be speculation. I
Yeah.
can tell you that we've had instances of the CSE, the Communication Security Establishment, picking up all the Wi-Fi passwords and information in an airport in British Columbia. So, we've had other examples of the police requesting or receiving subscriber information from TELUS. So it's not that these are one-offs. This is something that happens. And I'm sure that Scott is absolutely sincere and upholds his oath. But there are there are departments who believe, okay, we need to have this information, and we're taking it. And the problem is the net is huge. And since we're talking about the Charter, which as a lawyer, we also have to take oaths, the Charter actually has a really fantastic formula for figuring out these problems. Section 8, the right against unreasonable search and seizure, the court has found that within that right lies the right to privacy, which lies at the heart of a democracy. Privacy is important for so many reasons. I'm happy to iterate them. But very importantly, if we are going to allow a reasonable search or a reasonable invasion of privacy, we have a formula in Section 1 of the Charter. And what's very important there is that it must be necessary and it must be proportional. And that's what our concerns are, is that much of the surveillance that goes on is not necessary and not proportional. Secondly, the concern that we have with the new powers that are requested is that, sure, there are roadblocks, but we as a free and democratic society have understood that some roadblocks are necessary and can be got around. For the same reason, if there's a crime, we don't allow the police to come into everybody's house and search without a warrant. It's because we understand that the state can come up to here. After this point, they have to get a warrant. And so it should apply in the digital world as well.
Okay, let me play devil's advocate for a second. Should the media be immune from surveillance if police are trying to investigate a serious crime?
It all comes down to, did they have a warrant? And if we're talking about the Quebec example, in my opinion, based on the facts that have been reported, I don't know everything, but based on the facts that have been reported, if the police were surveilling a journalist in order to find out who that source was, and it's only compounded in my mind by the fact that they suspected the source was from among their own force or members, that's to me abusive and concerning.
I'm not going to ask.
But journalists play a very valuable role in our society. The freedom of the press is important, and they have to be able to have anonymity surrounding their sources. And so that's compromised as well.
I appreciate that, but we just watched an election campaign south of the border where one candidate, I won't mention his name, but he won. And he did so in part by demonizing media whom he thought had completely missed the boat and were biased and not worthy of the constitutional protections that they enjoy down there.
Yeah, but I got to say though, Steve.
Go ahead.
This is not, I'm not expecting anyone to lament the role of journalists in this case. Nobody cares that journalists are being surveilled. The issues are much larger than that. The fact is that journalists are simply the medium to convey very important messages. And if whistleblowers and sources, confidential, vulnerable sources, feel that they can't come talk to us, that means very important, vital public interest issues never get aired, nothing changes, and ultimately, it's all kept under the carpet. I'm not suggesting anyone should care about journalists being surveilled, but they should certainly care about the work of journalists not being aired and published.
Well, let's talk a bit here about what the public actually think about this. You want to bring this up, Sheldon? Christopher, I'll get you to comment on this first. As part of that CBC Toronto Star series, some polling was conducted which showed that while nearly half of Canadians believe we do have a right to complete digital privacy, 94% believe that police and intelligence agencies already have the ability to monitor our internet activities. Is that an accurate perception in your world?
I don't know anyone in the sort of mainstream academic community or Canadian civil liberties community that believes that there's an absolute right to privacy. We have privacy rights and expectations and norms, but no right up to privacy is absolute. Now, in terms of people's perceptions as to what authorities can do or not do, I think there's a series of problems. Part of it is the information that has come out over the years around these issues. This isn't the first time we've talked about these powers. They've been cycled through policy debates now for almost a decade. And any time we do get data, it's incremental and piecemeal. So to touch on subscriber data, several years ago, the Privacy Commissioner released information that in a single year, there were approximately 1.3 million requests for this that affected over 800,000 Canadians. So
1.3 million requests
across Canada, and it was a non-complete number of ISPs that provided responses that affected 800,000 Canadians or more. So these are powers that we have seen discussion about, but it's always fragments. And so in Canada, there's the authorities are only required to keep records under statute for the number of interceptions they do, so wiretaps functionally. And it means all the other policing powers that have been granted to them to pursue criminals over the past 3 decades or so, they don't have to keep track of. And so we don't actually know how often powers are used today. So when new powers are proposed or advanced, we're really having this discussion that we don't have data on the table. We have a series of cases, and it's really helpful that we have them on the table now. But we don't have that statistical data, which is what we really need to understand what is going on right now. Canadians don't know what authorities do.
Well, they don't know, but here's what 94% of them say. Deputy Chief, 94% of them say you and intelligence agencies already have the ability to monitor their internet activities. What do you make of that?
So the technical ability, I would say yes, if to a certain level. And I go back to that whole aspect of the mass surveillance program by police across Canada. And it's, in my opinion, it's not happening. Is it happening in the security industry or on the other side of the law enforcement community? Perhaps it is, but it's not happening in policing. So do we have? Yes, we do have the technology, and we have technology that is not leading edge, but we have technology that follows. I call it the following technology curve that we have. But I can give you an example of a child pornography investigation that was done a number of years ago, and I attended a media launch on it where we announced the results of a number of individuals arrested across Ontario, and we arrested between 40 and 50 individuals, but yet we identified 8,500 individuals that were perhaps accessing the same information, visiting the same sites. So to me that, yes, we do have the technology, yes, we can identify 40 to 50 individuals, but we're also aware of 8,500 individuals that were accessing the same information across Canada. So I think we do acknowledge that we have technology, we do acknowledge that we have an opportunity to leverage technology at times, but we don't have capacity. And I think the aspect of capacity to do is also very important. And then I hate to get to that discussion because it actually turns into resources. And that's a discussion no one wants to have
And
at
that's
any
about
level.
money at the end of the day. How did the situation you just described, how did that work itself out ultimately?
Well, 40 to 50 individuals are charged, and the other 8,500, and I'm being close on it, probably within 400 or 500 of that number, but no further action was taken at that time against those individuals.
And so it is or is not before the courts, or what's happening with it now?
The 40 to 50 are probably been before the courts. It's been 4 years since then, but the other 8,500 may or may not have been captured in some type of sweep somewhere. But that's not an uncommon story on child pornography investigations. It's that capacity and the ability to gather information in a lawful manner really limits the ability of law enforcement across Canada.
Gotcha. Robert, can you tell us the difference between evidence that's a product of the body and evidence that's a product of the mind? Help us understand that distinction.
It's fascinating legal concept. So we encountered this in the course of doing this work. So one of the 4 measures that the police want is a law that would allow them to, if you are the subject of a criminal investigation, to say, we believe there's evidence on your telephone, and we would like to access the telephone. We're unable to do so because of encryption. We can't get in, we tried, we can't get in. So we would like you to open that phone for us, please. So please give us your password and allow us to open that phone. And if there were a law, there would be, under criminal threat, you would have to either give that or not and face some sort of
Do it or be charged.
Right. So the issue this brings up, the legal issue this brings up is self-incrimination, right? So in this country, we have a law around self-incrimination. So,
meaning you can't do it. You're not obliged to do it.
right. So we put that to Commissioner Paulson and to the police authorities, and they raise a very, very interesting point. They say, okay, yes, we have a law around self-incrimination, but we as a society have identified exemptions effectively to that. We have decided that, for example, in cases of drunk driving, we compel you to blow into a machine. We compel you, because that is such a scourge in our society, we have agreed that we are going to ask you to provide us with evidence from your body.
To incriminate yourself, in
Which
effect.
will, if in fact you're drunk, that will self-incriminate you. And the other example I use is DNA samples. So in a murder investigation, you are compelled to provide DNA, which will allow police to gather evidence that could in fact be used against you in a murder trial, for example. So that's the argument. And so what the courts have done, this is mainly, the precedents are mainly American at this point. This is still very in development, I think, legally in Canada. But the notion is that courts have drawn a distinction between things like your breath and your DNA, which are products of your body, and the notion of supplying police with a piece of information contained in the mind. So your 4-digit passcode on your phone is, in fact, from here. It's not a product of your body, and therefore privacy advocates will argue that that's different. Now it gets even more gray, because increasingly on our phones, we use our thumbs.
Fingerprints.
Which is a product of the body. So where does that come?
That didn't make it any easier, did it? It's more confusing now. Can you, Sukanya, let me go to you on this one.
Because I was dying to jump in.
Oh, all right. Well, is there something you want? I've got a few minutes left here. I got one more thing I want to add, but did you want to follow up on
I just
something?
wanted to add to what Rob said. I mean, I think he's completely right in the sense that there has been a distinction between evidence of the body and evidence of the mind. But let's take that further. When somebody is breathing into a breathalyzer, there's been a reasonable suspicion that the person is drinking, or we as a society have decided, okay, this is an invasion of privacy that we will allow or deem reasonable. It fits that test in Section 1 I was talking about, necessary, proportional. We're only looking for one thing. Same with the DNA. We're only looking for a match.
Not
So
a fishing
its
expedition
use,
here.
exactly.
Okay.
It's all been, it's laser focused on what, if it's properly used and properly disposed of, which is a big if. But that in itself, there's a targeted collection and use and ultimately destruction of that piece of evidence.
Okay. I'm down to 30 seconds here, so
So-
I'm going to interrupt. I got to interrupt because I want to find out what's going to happen here. The
In
federal
fact,
government's got to make a decision about what it's going to do here. What are they going to do?
Well, hopefully they're going to remember that we've had decisions like Spencer, that we know that we've already got a roadmap. We've got the charter that's told us we can do searches as long as they're reasonable. We can't do mass surveillance. We can't do mass information grabs. I completely understand that Scott and his force might not be involved in some mass national surveillance, but we have to remember that the state has many different arms. There are institutions. We've already had reports. And we have the CSE that has access to different technologies. So privacy is there so that we can live freely and tell the state, you can come this far,
So you think the
but
federal
not farther.
government? You think the federal government will put the brakes on here and not give Scott and his?
No, frankly, I'm quite concerned.
You're concerned
because
they might.
I'm very concerned because the discussion has been framed in terms of fear and a threat to security as opposed to why the pros of privacy. We only look at the cons of privacy. We don't look at the pros. So I'm concerned about what might happen next.
Okay, I got to leave it there. We're plumb out of time. Can I thank the Deputy Chief from North Bay, Scott Todd, and Christopher Parsons from the U of T Citizen Lab on one side of the table, and there's Robert Cribb from the Toronto Star and Sukanya Pillay from the CCLA, the Canadian Civil Liberties Association, on the other side of the table. Appreciate your time, everybody.
Thank you.
Help TVO create a better world through the power of learning. Visit TVO.org and make a tax-deductible donation today.